A court win means little if your immigration file still sits untouched. A federal judge told USCIS to restart processing cases for nationals from 39 countries. Green cards, work permits, asylum cases, and naturalization applications were supposed to move again. But weeks later, many applicants are still seeing no change. If your work permit is close to expiring, your green card has not moved, or your immigration case is still stalled, stay with me. Today, I'll explain what the court actually ordered, why delays are continuing, and what you can do right now to protect your case. If you're navigating the U.S. immigration process, this video breaks down legal updates in plain language and helps you understand your options. This update matters for applicants from the 39 countries affected by the USCIS hold policies that began in late 2025. Even after a federal court rejected those policies, many people are still waiting without clear answers. This is general information, not legal advice. Let's look at what is happening. On June 5, 2026, a major ruling came from the U.S. District Court for the District of Rhode Island in Dorsis International Institute of Rhode Island versus USCIS. Chief Judge John J. McConnell Jr. said USCIS had to stop enforcing 4 immigration hold policies that froze benefit applications for nationals of 39 designated countries. Those policies had stopped thousands of applicants from getting decisions on important immigration benefits. The first was the General Benefit Hold, which paused processing of green cards, employment authorization documents, travel documents, and naturalization applications. The second was the Global Asylum Hold, which froze affirmative asylum decisions no matter where the applicant came from. The third was the Broad Re-Review Policy, under which USCIS reopened previously approved cases going back as far as 2021. The fourth was the Country-Specific Negative Factor Policy, where nationality alone was treated as a major negative point during review. The court said these policies were arbitrary, lacked a reasonable legal explanation, and conflicted with existing law. As a result, the judge vacated them, which meant USCIS was legally required to restart processing the affected applications right away. On June 12, 2026, the federal government filed an appeal of that ruling. However, here is the key point. An appeal does not automatically pause the court's decision. Unless another court issues a stay, USCIS is still legally required to keep processing these cases while the appeal is pending. Put simply, the appeal itself is not a valid reason for USCIS to leave your case on hold. So if the court ordered USCIS to resume processing, why are so many applicants still waiting? The main reason is backlog. Even before this ruling, USCIS was already handling a heavy workload. Now picture thousands of green card cases, work permit requests, asylum files, and naturalization applications returning to active review at once. That naturally creates delays. USCIS has restarted some cases, but many applicants are still seeing slow movement. Work permits are expiring. Green card cases remain pending. Naturalization interviews have not been scheduled, and asylum applicants are still waiting for decisions. Backlogs are understandable. But if USCIS is delaying your case because of the old 39-country hold policies even after the court struck them down, that raises a more serious legal concern. At that point, it may no longer be just a backlog issue. It could become a compliance issue with a federal court order. Now let's go through the practical steps you can take. 1. Check your USCIS case status often. Log into your USCIS online account regularly. Requests for evidence, biometrics appointments, interview notices, or final decisions can show up without much warning. Checking often helps make sure you do not miss an important update. 2. Request expedited processing. USCIS lets applicants ask for expedited review in certain situations. Qualifying reasons can include severe financial loss, urgent humanitarian issues, or medical emergencies. If your work permit expired and you lost your job because of it, financial hardship may support an expedite request. You can submit the request yourself or work with an experienced immigration attorney. With delays like these, it is usually better to act early instead of waiting until the last minute. 3. Contact your congressional representative or senator. Many people do not realize this option exists. Members of Congress have staff who help constituents with federal agencies, including USCIS. A congressional inquiry can prompt USCIS to review your file and give an updated status. It is a legitimate process, it can often help, and there is no cost to ask for this assistance. 4. Keep detailed records. Documentation matters a lot. Save screenshots from your USCIS online account. Keep copies of every notice, letter, email, and message. Write down the dates of phone calls, online inquiries, and service requests. If your case later needs legal action, these records can become valuable evidence of both the delay and your efforts to fix it. 5. Renew your employment authorization document early. If your work authorization is close to expiring, do not wait. File for renewal as soon as you are eligible. Current processing delays mean waiting too long could leave you without valid work authorization. Filing early helps reduce the risk of an employment gap. 6. Consider a writ of mandamus. If your case has been delayed for an unreasonable time, USCIS has given no meaningful explanation, and other efforts have not worked, there may be one more legal option. A writ of mandamus is a federal lawsuit asking a court to order the government to perform a legal duty. In this situation, that duty is making a decision on your immigration application. A mandamus case does not guarantee approval. Instead, it asks the court to require USCIS to act when it has failed to decide within a reasonable time. It is not the right step in every case, but for some applicants, it may become the most effective legal remedy after other options have been used. Here is something many people are mixing up. The June 5, 2026 ruling applies only to immigration benefit applications filed inside the United States that were delayed because of the 39-country USCIS hold policies. It does not apply to immigrant visa processing at U.S. embassies or consulates abroad. Those cases remain under the separate 75-country visa suspension, which the Dorsis decision did not address. So if your immigration case is being processed outside the United States through a U.S. embassy or consulate, a different legal analysis applies. A federal court has ordered USCIS to resume processing immigration benefits for applicants from the affected 39 countries. Although USCIS has started moving some cases, major backlogs are still delaying many applications. If your case is still pending, do not just wait without taking action. Check your USCIS account regularly, request expedited processing if you qualify, renew your work permit early, and if USCIS keeps ignoring its legal obligations despite the court order, speak with an experienced immigration attorney to see whether a writ of mandamus may be appropriate for your situation. Being informed and proactive can make a real difference in protecting your immigration journey. If you found this video helpful, please like it, subscribe, and turn on the notification bell so you do not miss the latest immigration news and USCIS updates. If you have questions about your immigration case, leave them in the comments below. We read your comments and use them to make future videos that answer the questions most important to our viewers. And if you know someone from one of the affected 39 countries whose case is still stalled, share this video with them. It may help them understand their rights and the steps they can take. Thanks for watching.